Ladies and gentlemen, I'm going to go ahead and start this meeting. We've got a few members that are on their way. And I believe we have one last speaker, Mr. John Monroe.
Thank you, Mr. Chairman and members of the committee. I apologize in advance for my voice. I've got a bit of laryngitis. John Monroe with GeorgiaCarry.org. I'm the vice president. GeorgiaCarry.org has about 8,000 members in Georgia. It's a grassroots organization supporting the rights of its members and other Georgians to keep and bear arms. Georgia Carry strongly supports this bill, so I won't go through any criticisms of it or even go through the points of it. But one thing I did want to do is address some of the criticisms that were raised either yesterday or today. And one thing Representative Hightower has already mentioned was the issue of signs. I think there was some thought yesterday that some property owners, such as churches, would have to erect signs if they didn't want to have guns. There's nothing in the bill that would require that. They're free to erect signs now if they want to. If the bill passes, they'll still be free to erect signs. I should mention, though, as a matter of criminal trespass law, putting up a sign saying no guns wouldn't really have any effect. You'd still have to either eject the person or exclude them under the criminal trespass law. Putting up a sign saying you can't come in without a shirt doesn't mean that if you come in without a shirt you've trespassed. It just means somebody's probably going to see you without the shirt and tell you to leave. I also wanted to address Representative Holcomb's question yesterday about pointing a gun or a pistol at another and why that was being stricken. I can't address why it was being stricken, but I can address the crime generally. It's a relatively minor crime, even though it doesn't necessarily sound like it, and that's because we have another crime, aggravated assault, which is charged much more frequently in a situation where somebody does point a gun at another. Although I've seen case law where people have been charged with pointing a gun or pistol at another, I've never had a client who has, and I don't even know of somebody who's had a client that has. I don't know if you've prosecuted any or not when you were a prosecutor, but the thing with pointing a gun or pistol at another is if the other person sees you pointing the gun or pistol at him, he's probably frightened by that, and that constitutes all the elements of aggravated assault, which is a 20-year felony instead of the misdemeanor of pointing a gun or pistol at another. Really, in order to be charged with pointing a gun or pistol at another, either the person has to see you point the gun at him but not be scared, or not see you point the gun at him. And those fact patterns just don't come up. It's pretty rare to see somebody point a gun at somebody else, but the person who is pointed at didn't see it, and this third party reports it and prosecutes it. It just doesn't happen. So as our gun crimes go, it's a pretty minor crime. I wanted to talk a little bit about the churches, since there were several comments on that yesterday that seemed to imply that if the bill passed, churches would be required to allow people to carry guns there, which of course is not the case. What really astounded me yesterday, though, was the number of representatives from churches or faiths that was actually asking the government to step in and interfere with their own operations. In fact, I think one minister said, "We can't manage our own affairs, so please come criminalize it for us." Frankly, I'm astounded that a church couldn't manage its own affairs, but if it can't, it's not the business of government to manage churches. The First Amendment prohibits that. And somewhat ironically but tragically, while this bill was being debated yesterday, there was a church shooting in Lithonia. And I think one minister said that Georgia should not be the leader in this area, somewhat implying that if Georgia were to decriminalize carrying guns in churches, that would make Georgia somewhat of an outlier. In fact, the opposite is true. Georgia is an outlier today. 45 states do not criminalize carrying guns in churches. Georgia is one of the very few that does. Georgia's being the leader in the wrong direction. Now, I think there was a complaint yesterday that there's not a provision in the bill to suspend a license for somebody who was convicted of carrying a gun in an unauthorized location. Well, that's technically true because under current law, you can have your license revoked for carrying a gun in an unauthorized location. There's no need to suspend a license after it's been revoked. There also were multiple complaints about the airport language in the bill. Some people somewhat derisively describing a situation where a person inadvertently carries a gun through security, and why that shouldn't be something, and criticizing what the bill would do with that. The people who were making that argument seemed to think that under current law it would be a crime for someone to carry a gun past security in an airport. But that's not true. If you look in the books in Georgia today, if you have a license to carry a gun, there is no crime for carrying a gun past the security in the airport. Not a state crime. I know people get arrested for it all the time, and the Clayton County Solicitor may charge you with carrying a gun in an unauthorized location in violation of 1611-127. But there are only 8 locations listed in 1611-127, and none of them is the airport. It's not a crime to carry a gun past security in the airport today, and this bill would criminalize it. And people who apparently didn't like the idea, thank you very much, people who apparently didn't like, who don't like the idea of carrying guns in airports, nevertheless criticize the bill for that. And this bill would actually criminalize what currently is not a crime today. I've heard comments both yesterday and today about the public gathering law. I think, in fact, the former representative who spoke yesterday talked about what's written on the back of a Georgia weapons carry license and how it quotes the public gathering law. And I just wanted to point out to the committee that law was repealed in 2010. It hasn't existed now for 4 years. And it's no longer a crime to carry to a public gathering, and the language she was talking about is no longer printed on licenses. Just briefly on the carrying of guns in schools, I know there are some comments against that. One other thing I'd point out is current language in the law in 1611-127.1 allows school officials to allow anyone to carry a gun in school. Presumably that means I can get permission from a school principal to carry a gun in my child's school just with the stroke of a pen from the principal. And what this bill does is create a separate path whereby the school board can designate people to be carrying guns, allow for training and things like that. It's really a more restrictive path. I guess my point is, if there's not an issue with the way things are being done today, this more restrictive path certainly wouldn't be any more of an issue. One more drink. Then I've heard some talk today about guns and alcohol, carrying guns in bars. It's already legal today to carry guns in restaurants that serve alcohol. That's been the case since 2008. And since 2010, it's been legal for people who are carrying guns in restaurants that serve alcohol to consume alcohol. It remains illegal to discharge a firearm while intoxicated. But under Georgia law, the only difference between a bar and a restaurant that serves alcohol is how much food they sell. Otherwise, they're the same thing. We haven't had any problems that I've heard reported anywhere on people carrying guns in restaurants that serve alcohol, and there's no reason to believe that we would have problems in establishments where they don't sell quite as much food. Now, multiple people have testified that, I guess from a somewhat emotional reaction, that they just want to keep misdemeanor crimes in place that make it a crime to carry a gun in a certain location, apparently under the belief that the existence of the misdemeanor will somehow prevent somebody from committing a serious felony. That's not really a rational belief, because someone intent on committing the serious felony with a gun certainly doesn't care about the misdemeanor they might also be charged with for carrying a gun where it's not authorized. Then a couple comments on the GMAACCG suggestions. If you were to have the Attorney General office be the sole body with a private right of action to enforce the preemption statute, that would mean that the Attorney General would have to prioritize whatever violation there was with other pressing matters the Attorney General has to deal with. A municipality could, if it chose to, thumb its nose at the law and hope the Attorney General just doesn't have the time to deal with it. If you don't think that would happen, I can give you an example. A few years ago, on behalf of GeorgiaCarry.org, I sued several municipalities in Fulton County, all of whom had ordinances banning carrying guns in city parks. It was all one case, GeorgiaCarry.org versus like 8 different municipalities in Fulton County. Within a few weeks of filing and serving the defendants, all of the defendants except one changed their ordinances so that it was no longer a violation to carry a gun in a park. All except one. The City of Atlanta refused to change its ordinance. Filed a motion for summary judgment. We went to court. The Superior Court judge held up an opinion from the Court of Appeals saying the preemption statute says what it means. Why am I not bound by this? Why don't I have to enjoin you from enforcing the ordinance? And the city said, I don't know, we just don't want to change it. So the city of Atlanta made us go through the time, the trouble, and expense of dragging them to court, having multiple hearings, only to put off the inevitable of us getting an injunction against the City of Atlanta, and it costs a lot of money to do things like that. And if municipalities are going to insist on making us do that in order for them to do what this body tells them to do, then they ought to have to pay the expense of doing that. And lastly, the bill doesn't really have anything to do with courthouse security plans. Courthouse security plans by law are confidential. They're not public record, they're not public documents, they can't be examined by a member of the public. I can't go to the sheriff of Fulton County and say, I want to see the Fulton County courthouse security plan. By definition, that means there's no regulation of the public in that document. There can't be something in that document saying, and you can't carry guns in the courthouse, because the sheriff can't enforce something against me in a confidential document. If it's going to be something I can't do, it has to be public. If it's not public, it's not enforceable against me. The things that are in the courthouse security plans, presumably then, are internal operations, what you do if there's an emergency, who goes where, who hides where, who goes out what door, and things like that. But the courthouse security plans are separate from what the public is or is not allowed to do in a courthouse. Those are the comments I had, Mr. Chairman, but I'd be happy to answer any questions.
Thank you, John. Any questions? Ms. Waits, of course.
Thank you. Generally, would you not agree that patrons go to bars exclusively to consume alcohol? Is that reasonable?
No, I don't think that's true.
Okay. Would you be open to a friendly amendment that would require our concealed weapons permit holders to at least know how to load, unload, and shoot a weapon? Is that reasonable?
Ms. Waits, he's not the author of the bill, and he's not on the committee. You are. So he can't accept an amendment. You need to pose that to the committee.
Okay. Thank you, Mr. Chair. That was the last question.
Any other questions? Do you have any questions? Thank you. Appreciate your time in this issue.